North case, including bed sore cases. Attorney Ted London can represent you and your family.
Good morning, everyone.
Good morning.
Good morning.
Hi, thank you all for joining us this morning. Hi, I'm Attorney Ted London, and we'll get started right on time this morning. Yeah, I'm so happy to see so many of you joining us. It's really great. My assistant Jada worked so hard to invite all of you to join this estate planning seminar, so you can get some information. Hopefully, you can share it with your friends and family as well. Again, you can always call us at our office. Our office number is 773-721-3333. You can always come by our office. We're in Chicago. Our office address is 1718 East 87th Street. And of course, you can always go online. We have a terrific online presence, again, thanks to Jada. We have a website, believe it or not, we have TikTok. Ted London's on TikTok. Who would have thought? Facebook and other platforms online that you can go and get some of the information as well. I think we're going to have a way for you to email questions in, and then I'll be able to answer some of your questions down the road. Let's see. You know what? We know we have some of you who are from out of town and out of state. And so for those of you who are out of town, out of state, you know what? We thank you for joining us this morning. Again, we do this estate planning seminar every first Thursday. So some of you may want to invite some of your friends to come in and get some information, or at least share some of the information that you're going to gather today with some of your friends and family. I would suggest that if you don't have paper and pen, that you take a moment and get a paper and pen so you can take some notes. Here's one of the things I discovered. It's an easy way for me to always find or discover if my client is an educator or a retired educator, because with educators and retired educators, the first thing they always do is get a pen and pad out and start taking notes. Jada, something seems to be wrong with my looks like we're having some technical difficulties. Give me a few minutes and let's see if Jada can correct this for us, and then we'll get started. That was easy. Got it. And if you can you please mute your computers so we won't be distracted. So let's get started. So again, we're here to share some information about estate planning today. So many African Americans, they don't have a lot of information about estate planning, and oftentimes the information that they have is incorrect. Let's see if I can correct this again. Got it. Oftentimes the information that they have is not actually correct information. We get so many people that come in and they're telling us that they've heard things from their neighbors, from their friends, from their relatives, and oftentimes it is just not correct. Please forgive us. I'm not sure what the technical difficulty is. Let's try this one more time. Hey, Jada, can I check out and come back in? Oh, Please forgive me. Got it. Let's see. Okay. Got it. Okay. I think I have it here, Jada. I guess it's, yes.
It must be your camera
Is
though.
my camera?
Is it glitching like this in the Zoom?
No. Let's see if that works.
Okay.
Got it. Thank you. Okay, let's try this again. Again, so oftentimes African American folks have just, please forgive me. You know what, if we're gonna try this again, worst case scenario, I'm just going to take my live feed off and I'll just go to the pictures and then you'll still be able to hear me. So I don't have to keep interrupting. So please forgive me. I hope you all can hear me. And then in a few minutes, I'll see if I can go back live and let's see if the picture gets any better. Again, so we're here to talk about estate planning and I'm happy to share some information with you because again, so often African-American folks, they just don't have good information. So one of the first things I want to start with is really advising you that you don't want to have a will, no wills. Now, so many of you believe, and wrongly so, respectfully, that if you have a will, it will keep your home, your money, and your things out of the expensive, time-consuming, stressful probate process. Well, it's absolutely untrue. If you have a will, it will absolutely categorically send your loved ones through the expensive, time-consuming, stressful probate process. So believe it or not, rule number one for efficient estate planning is no wills, okay? So there are three primary things that we want to keep out of probate court when we're doing estate planning for our middle-class families. And that's another issue. So oftentimes, African-American folks don't really believe that they're middle class, or they don't believe that they have enough resources and assets to even do estate planning. And I'm always so surprised by that because oftentimes when clients come into our office and we start putting together what they have accumulated over the lifetime, real estate, financial accounts, life insurances, people are often surprised at how much they are actually worth. So all Black folks aren't poor. There are many, many, many middle-class African-American people. And for those of you who are middle class and even upper middle class, again, there are three primary things that we want to keep out of probate court. The first thing that we want to keep out of probate court is the real estate. We want to keep the real estate out of probate court. And two ways that we can really keep the real estate out of probate court. Typically, if we are in Chicago, I like my clients to use a land trust. If you have your property in a land trust has a number of benefits. The first benefit is you get to name who gets the property after you, and whomever you name will get the property very easily without going through the expensive, stressful, time-consuming probate process. You can name all the kids or just the good one. That's up to you. But whomever you name, they'll get the property very easy without going through the probate process. That's one of the benefits of having the property in a land trust. Another benefit of having a property in a land trust is if you have your property in a land trust, if you are ever sued, the judgment will not attach to your home, okay? So if you have your property in your name personally, and if you are sued, if that judgment is recorded, it automatically attaches to your home. If you have your property in a land trust, it will not. To give an example, some of our clients have multiple properties, and there have been occasions when one of the properties have gone into foreclosure. So they didn't want to keep that property for whatever reason, but they were concerned that the foreclosure judgment would attach to their personal property, the property that they want to keep. So if we put that property that they want to keep in a land trust, if that one property is foreclosed on, and if that judgment is recorded, it will not attach to their primary residence. So that's one of the other benefits of having a property in a land trust is it stops judgment from attaching. The third benefit of a land trust is if you have your property in a land trust, there is a privacy benefit. If someone runs your name now, they can see what property you own, and they can see all the property that you own. They can see where you live and all that information. If someone runs your property address, they can discover who the owner of the property is. if you have your property in a land trust, if someone runs your name, your property is not going to be able to be discovered. If someone runs your property address, the person that's running it is not going to be able to see that you are the owner of the property. So it's a privacy benefit. So we have a lot of elected officials that come in to put their properties in a trust. We have a lot of pastors that come in and put their properties in a trust. A lot of educators, a lot of police officers, a lot of judges who come in and put their properties in a trust. A lot of retired folks come in and put their properties in a trust because they like the privacy benefit as well. The reality is all real estate should be in some sort of trust. You want to keep the property out of probate court. While the property is in trust, you are still in 100% control of the property. You can still sell it, rent it, refinance it, kick anybody out that's in there, evict anyone. You have 100% exclusive control of the property. But once you pass away, whomever you named will get the property very easily, again, without going through the expensive, time-consuming, stressful probate process. So when you're passing your real estate, whether you have one home, multiple homes, single-family homes, multi-unit properties, whether the property is paid for or not, it should be in a land trust, period. Again, you can still sell it, rent it, refinance it. You still have 100% control of it. The people that you name to get the property after you have no interest in the property at all until you pass away. And in the meantime, if they get on your nerves while you're still living, you can change them very easily as well. So just because you name someone to get the property after you, if they get on your nerves in the meantime, you can still change them easily. So the bottom line is, for the real estate, you want to keep that out of probate court. And the way that you do that is you have it in some sort of trust. The second thing that we want to keep out of probate court is you. We want to keep you, the individual people, out of probate court. People can go to probate court while they are still living. So you have to have someone in a position to be able to make health care and business decisions for you in the event that you ever need someone to make health care and business decisions for you. And the way that you do that is you must have power of attorneys. There are two kinds of power of attorneys. There is one for health care and there is one for business matters. Everyone needs them both. And here's what we find so interesting is that we have so many clients, and we're so proud to have so many long-term married African-American couples as our clients. So we have many clients married 50, 55, 60, 65. I think the longest married couple we had the pleasure of serving, they were married for 72 years. They were both 92 years old. And these 92-year-olds were not like old 92-year-old people. These are both walking, energetic 92-year-olds. The good news is people are living much longer. But the research suggests that as we age, we need to have someone in a position to make decisions for us if we ever need that to occur. But just because people are married and they have been married for 50, 60 years or longer, that does not give you the right to make healthcare nor business decisions for one another without power of attorneys. So even married people need power of attorneys for their spouses.
What do you say? Healthcare.
Again, there are two kinds of power of attorneys. There's one for healthcare and there's one for business matters. Again, everyone needs them both. Again, even married folks need them. And certainly if you are single, you need to have someone in a position to make decisions for you if you ever become incompetent. Again, now here's what's going to happen to a person that ultimately needs someone to be in a position to make decisions for them and they don't have the power of attorneys. Their loved ones are going to have to go through the expensive probate process to have someone named as their guardian. That's a very expensive, very complicated process. And that is a process where your loved ones go to fight to get in a position to make decisions for you because they're of the mindset that if they are in a position to make decisions for you, they're going to get close to the what? Yes, the money. And so you want to have someone that you have selected while you are competent to be in a position to make decisions for you if you ever need someone to do that for you. Again, we get many calls where people want us to do power of attorneys for typically a parent, spouse, sometimes their siblings, sometimes grandparents, but it is too late because the people are no longer competent. Once a person is no longer competent, then they cannot sign any documents. You have to be competent to understand what you're signing. So once a person has dementia, Alzheimer's, some of those things, oftentimes it is too late because their cognizance level is just not there for them to understand what they're signing. But I want to be clear about something as well. Just because someone has been diagnosed with dementia or Alzheimer's, that does not automatically preclude them from being able to make decisions and understand what they may be signing. But it does get to a point where they are just not competent to understand, and it is too late for them to do any of this estate planning. And then your loved one's going to have to go through the probate process to transfer the home once they pass away. And they're going to have to go through the probate process in the event that they need to make decisions for a loved one. I'll give an example. I had one client that called me not long ago. Her mom had dementia. Her mom had just received a $300,000 check. And so she wanted to be able to deposit the check in the bank. And mom had other money as well, and to use the money to pay some of mom's expenses, but she didn't have power of attorneys for mom. She could not sign the check to deposit it. She could not get access to mom's money to pay mom's expenses. So what did she have to do? She had to go through the probate process to be appointed mom's guardian. Had to pay a lot of money to some lawyer for that. Unfortunately, it was me, but it could have easily been avoided had she just had the power of attorneys. You have to have the power of attorneys before you need them. If a person becomes incompetent, it's too late. If you need to make decisions for them, then you're going to have to go through that expensive probate process to be appointed their guardian. So please make sure that you have power of attorneys for yourselves. I just want to say this to the ladies as well. And no offense to the men, but ladies are more likely caregivers for our family members and for our community in general. And so some of you ladies are going to be caregivers for parents, for spouses, for siblings sometimes. Here's what we find interesting. Sometimes ladies come in and to get their ex-husband's affairs in order. I always find that so fascinating. And the reason that they do it is because they want to make sure that their children are not going to have to go through the probate process when the ex-husband or the children's fathers pass away. So that is not uncommon for a ex-wife to bring her ex-husband in. Clearly, he's not remarried, but to get his estate planning affairs in order. Here's what's interesting. In any of those cases, have I ever seen where the ex-wife wanted any portion of it for herself? They always want to make sure that their children are going to get what they're going to be entitled to without having to go through the probate process. So some of you ladies may want to encourage your ex-husbands to come in and get your affairs in order. But aside from that, you ladies are caregivers. And so you want to make sure that if you're looking down the road into the future and you see someone that you may need to be in a position to make decisions for down the road, you want to make sure that it's going to be easy for you to do that, make decisions for them, that is. And the way that you do that is by having both the power of attorneys, one for healthcare, one for business matters. Okay, so let's talk about those power of attorneys. Again, there are two. There's one for healthcare, there's one for business matters. The power of attorney for healthcare is the one where you are naming someone to be in a position to make healthcare decisions for you if you ever need someone to do that for you. Also on the healthcare power of attorney, you get to name and indicate if you want to be an organ donor or no. And you also get to indicate how much care you would want if you were in an irreversible coma. That is, would you want to stay on life support or be taken off? That's all on the healthcare power of attorney. Many of you already know this, that if one of your loved ones goes to the hospital, if you go to the hospital, one of the first things that they ask is, do you have power of attorneys? Now, I know some of you may have power of attorneys that you have signed at the hospital. I just want you to be mindful that power of attorney is only good for that healthcare facility. It is not a universal power of attorney that if you go to another hospital, that power of attorney is going to transfer. That is only for that healthcare facility. And so if you've done that at a hospital, you still need to do your own, because you just never know where you're going to end up. If you're going to be somewhere in the state that you're at, if you're going to be traveling, you need to have your own, where it's going to be universal wherever you go. For the healthcare power of attorney, you get to name two people. You get to name a primary decision maker, and you get to name a secondary decision maker. So if the primary person is unavailable for whatever reasons to make decisions for you, you've already named a secondary person in the document itself. So that's the healthcare power of attorney. Then there is what's called a durable power of attorney. That's what's called a power of attorney for property. And that's the power of attorney where you are naming a primary person to be in a position to make business decisions for you, sign checks, pay bills, deal with Social Security, pension matters, any kind of file taxes for you, write checks, any sort of business matter that there is. If you have a power of attorney for property, the person that you named will be in a position to make those business decisions for you. And again, with those power of attorneys, you get to name a primary person and a secondary person. I want you to be mindful that power of attorneys are only good while a person is living. Oftentimes we get calls and people are saying that a loved one has passed away, and one of the first things that they say is, well, I was their power of attorney. Well, once a person passed away, those power of attorneys are absolutely 100% void. Power of attorneys are only good while a person is living. Once a person passes away, then those power of attorneys are void. That is why it is so important to do some of these other things, put the home in a trust. And we're going to talk about keeping the money out of probate court as well, because once a person passes away, if you have the property in a trust, whoever you name to get the property after you will seamlessly get the property without going through the probate process. So again, there are three primary things that we want to keep out of probate court: the real estate, single family, multi-unit, multiple properties, commercial property, property down south, property that's paid for, maybe still a mortgage on it. All those properties should be in a trust 100%, okay? Every property should be in some kind of land trust. Again, I'm just going to go back to the beginning and say this one more time, because I know people often can't believe it, but we never want to do a will. If you have a will, your loved ones are going to have to go through that expensive, time-consuming, stressful probate process. So please, no wills. Some of you who have just joined us, please forgive me. I am not live here because when I try to go live, I'm going to try it again. It's doing some hokey thing here. So let's see if it's going to work again for us here today. Again, I'm Chet London. Thank you for joining us. We do this seminar every first Thursday. Again, it's not working again, so I'm going to stop it and I'll just keep going without it. We do this every first Thursday. So again, thanks for joining us. Tell some of your friends and families to join us next week, or I'm sorry, next month. And I hope that you are taking some notes so you can share some of this information with your friends and family, because again, so oftentimes Black folks, we just don't have good information. Here's something interesting. A lot of white folks don't have a lot of good information either. When I go to probate court, when someone has passed away and they have to go through the probate process to get the home transferred or to get the money transferred, the courts are packed with white lawyers representing white families who didn't do estate planning either, or who didn't do it properly. I'm going to give you a little bit of a lawyer inside information. Are there any lawyers out there? If so, raise your hand online so I can see you and I can ask you to mute your things for a second. Well, here is some inside tidbit for lawyers when it comes to estate planning. A lot of lawyers don't have an interest in telling you or sharing with you how to keep your assets out of the probate process, because probate for lawyers is a very lucrative area of practice. The research suggests that the cost of probate is typically 1 to 3% of the value of the estates. So just think, if you have a $300,000 home, you have some money in the bank, that's 1 to 3% of that very, very easily. Okay, so, and it can be more if your children start fighting and contesting things and those kind of things, which people do all the time. But lawyers don't really like to advise their clients on how to keep their things out of probate court, again, because probate is very expensive for the client and is very lucrative for the lawyer. And let me tell you just a couple of inside tricks that lawyers do to make sure that you and your families go through the probate process, and that they make sure that you use that lawyer as the lawyer that probates the estate once you or your loved one goes to heaven. There are two ways that lawyers do it. One way is, if a lawyer does a will for you, well, we automatically know that your loved ones or you are going to have to go through the probate process. So, well, here's one thing: we're all going to pass away, and the lawyer wants your family to come back to his office or her office to probate the estate, because they're going to do pretty well. So here's how they make sure that occurs. There are one of two ways. One way is they keep the original will. If you have a lawyer that keeps your original will, well, and I don't know if it's unscrupulous or not, I don't think it is per se. But what he's doing is he's keeping your will because he knows when you go to heaven or your family goes to heaven, that they're going to have to come back to that lawyer to get the original will. And it is likely that that lawyer is going to be a lawyer that's going to probate the estate. Ching, 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 ching for the lawyer. Now, again, if you do a will, it's going to have to go through the probate process. So there is, there's really, I mean, it's not illegal. It's not even immoral. It's not even unconscionable. But it is just a tactic that lawyers use to make sure that if they're going to do a will for you, when you go to heaven, it's going to have to go through the probate process. That lawyer doesn't want you to go somewhere else. He wants you to come back to their office, he or she. And the way that they get you to do that is they keep the original will. So when you or your loved ones go to heaven, you got to go back to that lawyer and they're going to charge you and they're going to do pretty well. Another way that lawyers, smart lawyers, make sure that if you go to heaven and they're preparing the estate planning for you, that you are going to come back to them is they actually and literally write themselves into the will. So if you have a lawyer that prepared a will for you, and if he did not write himself in the will, I wouldn't even consider him a smart lawyer. Okay, so because when I was doing wills for my clients, I have not done a will for my clients in over 20 years because we want to keep our clients' assets out of the probate process. So there's no reason for a will. But when I was doing wills early in my legal career, I would write myself in the will, nothing illegal about it, nothing wrong about it. The only thing I would say in the will, I'll add a paragraph in is that upon the passing of this person, Attorney Ted London's office will be the office that will probate the estate of XYZ. Well, there's nothing wrong with that. Someone's gonna have to probate the will. The client doesn't object to it because I'm the one that prepared the will, so why not me be the one that probate the will? So there's no objection to it. I'm gonna get paid just like any other lawyer that will get paid, but that way I'm ensuring that your family's gonna have to come back to my office to probate the estate once you or your loved ones go to heaven. So that's the way that lawyers make sure that you go through the probate process by doing a will for you as opposed to estate planning that's going to keep your things out of probate court. And then they keep your original documents to make you come back to them to probate your estate when you or your loved ones go to heaven, and or they did like I did, nothing illegal, nothing immoral, nothing wrong about it, nothing cheating about it. Someone has to probate the will. I would just write myself in the will just to assure that when you or your loved ones went to heaven, you would come to my office and we would give you terrific service to probate your will. Now, again, I haven't done a will for my clients in over 20 years because, again, we want to save you time and stress and money from having to go through the expensive, time-consuming, stressful probate process. Again, if you don't get anything out of this seminar at all, please know that if you have a will, you're going to have to go through the probate process. You don't want to have a will, period. Again, there are three primary things that we want to keep out of the probate process: the real estate, the person, and the money. So we talked about a land trust. That's one way to keep, or a living trust as well. We'll talk about a living trust in a second, but you want the property in a trust for sure, okay? And then you have to have power of attorneys for yourself. There are two kinds of power of attorneys, one for healthcare, one for business matters. Everyone needs them both. Whether you're married or single, you have to have power of attorneys. You have to have them before it is too late, because if you let someone get to the point where they're no longer competent, then it's going to cause a lot of havoc and it'll cost a lot of money to have to go through the probate process to be appointed someone's guardian. So you got to get those things done while you can before it's too late. Now we want to talk about the third thing that we want to keep out of probate court, and that is the money. We want to keep the money out of probate court. And the way that we advise our clients to keep the money out of probate court is just by, first of all, making sure that they have beneficiaries on all of their financial accounts. If you have beneficiaries on all of your financial accounts, whomever you name as the beneficiary will get the money very easily upon your passing without having to come to some lawyer to go through the probate process to collect the money. So we're talking about checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies, annuities, bonds. If you have any of those accounts, if you have beneficiaries on all of those accounts, every single one of them, then when a person goes to heaven, then whomever they name as a beneficiary will get the money very easily without going through the probate process. Now, not only is it important for you to have beneficiaries on those accounts, they have to be current beneficiaries. We've seen people who still have ex-spouses named as beneficiaries, people who have passed away, still named as beneficiaries, people they don't even know where they are as beneficiaries, heck, people they don't even like anymore as beneficiaries. I'll tell you a case. We had a lady come in maybe a year or so ago. She had been married to her husband for 8 years. He was about 48 or 49 when he passed away unexpectedly at work. He worked for UPS. He had a $500,000 life insurance policy, but although they had been married for 8 years, he never changed the first wife as the named beneficiary on the life insurance policy. First wife got the $500,000 tax-free lump sum. The second wife was my client, and she wanted to know, was there anything that she could do? She wanted to sue UPS, she wanted to sue the ex-wife to get the money. There was absolutely nothing that she can do. Those beneficiaries are typically ironclad, and all because he did not do a simple thing by updating the beneficiary, then the first wife got the money. Had another case where we had a 90-year-old retired police officer pass away. He had never been married, no children. And he had his mom as his beneficiary. Well, his mom passed away long before him. He passed away at 90, so he had one sister and no wife, no children. And so the sister was going to be the heir. Well, because of the size of the life insurance policy, she had to go through the probate process to collect the money. I was a lawyer. You know what? I did pretty well on that deal, all because he did not update the beneficiaries on his account. So on every single account, not only is it important that you have beneficiaries, but you have to make sure that they are current beneficiaries. The second part of keeping your money out of probate court is not only is it important for you to have beneficiaries on all of your accounts, but your loved ones have to know where the accounts are. If your loved ones don't know where the accounts are, they cannot collect the money. We get calls practically every day where someone is calling and asking us, can we help them find the savings accounts, checking accounts, life insurance policies for a loved one that has passed away? The answer is no. We cannot help you find information about your loved one's accounts when they pass away. There is no central database where you can just put someone's date of birth in, social security number in, and all that information pops up. You cannot even call an insurance company or a bank or a investment house, and they would even confirm with you whether or not there are any accounts there without knowing it, especially if you are not the beneficiary. So not only must you have current beneficiaries on all the accounts, but your loved ones need to know where they are. So we give our clients what's called an estate plan and inventory book, where you'll list all of your account information, beneficiaries, institution, account names, and numbers. Balances are not so important. They don't necessarily need to know the balances until they need to know, but they have to know where the accounts are. Otherwise, they're not going to be able to collect the money. Here's what we're finding. There was a time when I'd be able to advise my clients to keep an eye on their mailboxes, because I would tell them that you're going to get statements monthly, perhaps quarterly, so you'll be able to, get an idea where the accounts are, how much are in the account. But so many people are doing online banking now that when a person goes to heaven now, they're not getting the monthly statements or the quarterly statements. So it becomes even more difficult for your loved one to discover where your accounts are if they don't know where they are. I actually just read an article last night where it was saying more money than ever is now going to the state when people pass away because the loved ones can't find the accounts. And then so you didn't have to wait 7 years. I think the article said almost something like 1 in 4 people, I'm not betting 1 in 4, 1 in 7, of all people are entitled to some unclaimed funds that some state may be holding on their behalf. Unbelievable. We had one client that came in. She was, her husband had passed away some years ago. And just in the course of our conversation, she was telling us, well, I think he may have had some money. I don't know. She didn't really need the money. She was kind of a senior lady, had done really well for herself. Her husband had left her in great condition. She was a retired educator. And so she wasn't hurting for the money. But just in the course of the conversation, she was telling us that she thought that her husband had some more accounts. Well, we went to the appropriate website here in the state of Illinois, and she got $80,000 within a matter of 10 days after we discovered the money. It was a very easy process to collect the money. But I think he had been passed away for 10 or 12 years. So you don't want to have to wait, or your loved ones to wait 10 or 12 years to find the money well down the line. You want to make sure they can get it relatively seamlessly once you go to heaven. One of the easiest ways to do that, again, is just to make sure that you have current beneficiaries on all of your accounts. Here's one thing I never advise, and that is adding your children's name, grandchildren's names, boyfriend's name, girlfriend's name, heck, sometimes even a spouse's name on your account. Let me retract that. Joint accounts are fine. But other than a spouse, please never add anyone's name to your account. I've seen horrible things that children and grandchildren have done against their parents in terms of withdrawing huge amounts of money out of their parents' accounts because they had the right to do it because they were on the accounts. So we don't want your loved ones to have access to your account, because if you add them as a signor on the account, that makes them an owner. And here's the downside of that as well. If you add a child's name to your account, if that child is sued, they can actually collect the money from your account. Okay, and so we don't need, and so some of you are asking, well, what happens if someone needs to get money to make decisions for me and care for me? That's what the power of attorneys are for. It allows them to access money, write checks, deposit checks, but it doesn't give them ownership of the account. And they still have a fiduciary duty to protect you with the use of the power of attorney. If you add them as a signor onto the account, then they actually own it. Tell you a story. Had one family that came into our office, and dad had a little bit of dementia. 3 of the kids came in, 1 of the kids didn't come in, and they had just discovered that the one brother who was on the account had taken out $85,000 from dad. And so just in the course of that conversation, I said, well, you guys should probably go back and do an audit to determine had he taken any other money out. And it turns out over the year, he had taken out over $120,000 over the previous year before he took out the lump sum, $85,000, bought a new car and moved to Las Vegas. So there was really no recourse because dad had added him to the account as an owner. So please don't add your children on your account. If they need to make decisions for you or write checks for you or pay bills for you, withdraw money for your benefit, whoever you name as a power of attorney can do it. But again, power of attorneys are void once a person passes away, and then whomever you name as the beneficiary will be entitled to the money. Just another tidbit about beneficiaries and funeral costs and expenses. Just because you name someone as the beneficiary on a life insurance policy does not obligate them to use those funds for your funeral expenses. Just be mindful of that. We've seen many, many cases where people were named as a beneficiary on a life insurance policy. They collected a life insurance policy and they said, listen, I have my own bills. I'm not paying any of these expenses. So just be mindful, just because you name someone as a beneficiary on life insurances or any of those accounts, it does not obligate them to do anything that you ask them to do or even expect them to do, because at that point, they are the sole owners of those accounts. So another way to keep your money out of probate court, again, there are 2 ways. One way is free, very simple, very efficient. Make sure you have current beneficiaries on all of your accounts. Another way to keep your money out of probate court is with what's called a living trust. If you have a living trust, there's additional cost for a living trust. Not everyone needs a living trust. Here are the people that should consider the additional cost of a living trust. One, if you're leaving money to special needs loved ones, then you want to leave the money through a living trust. Because if you leave special needs loved ones money directly, it will cause them to lose their SSI benefits. Or if you're leaving money to minor children, many of our clients have done really well for themselves and they want to help fund their grandchildren's education. So if you want to leave money to minors, grandchildren, help fund their education, then you want to leave them money through a living trust. You cannot leave minors as beneficiaries on your accounts. Or if you just don't want your adult loved ones to get the money in a lump sum. Again, some of our clients have done really well and they do not want their children to get all of the money at one time. So they set up a living trust, because in the living trust, you can set out the specific conditions that's going to outline what's going to entitle your children to the money. You can get some every year when you turn a certain age, if you get married, if you divorce the person that never liked in the first place, then you can have some of the money. Any condition that you want that's going to entitle your children to the money, you can actually lay that out in a living trust. If you just name them beneficiaries on the accounts, you cannot add any conditions, and whomever you name will get their portion in a lump sum. So again, we're talking about keeping the money out of probate court. There are two ways. One way is having beneficiaries on all your accounts, make sure they're current, make sure your loved ones know where they are, and then your loved one's going to get the money very easily. It is free to do if you do it that way as well. And you have to make sure that you have current beneficiaries on every single account. Again, checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies. That was going to keep those funds out of the probate process. Some of you may need a living trust. Again, here are the people that should consider a living trust. Again, there's a fee for a living trust. Here are the people that should consider it. One, again, if you're leaving money to special needs loved ones, some of our clients have special needs kids. They want to take care of the kids once they go into heaven, but they don't want to jeopardize the kids' SSI benefits because it is so hard to get. And if you leave the money directly, it will jeopardize the SSI benefits. And then once the money that you left them has been exhausted, they then have to reapply for the SSI benefits. And that's a year or two length of time process to be reinstated. So you don't have to do any of that if you leave the money through a living trust. They get the benefit of the SSI and they get the benefits of the money that you leave them. Another reason why you want to, again, invest in the living trust is, again, you leave your money to minor children. Or thirdly, if you just don't want your loved ones to get the money in a lump sum, then you want to leave them the money through a living trust. Let's talk a little bit about a living trust and how a living trust operates. A living trust is a document that that lawyers prepare. And even though there's a number of pages, there's really only 3 or 4 really important things that you should really know. One thing is, who is what's called the trustee of the living trust? Well, you're likely going to be the sole trustee of your own living trust. Or if you're married, you and your spouse will be co-trustees. That means you're going to control everything in the trust. But when you pass away, the trust does not end. So you're going to name what's called a successor trustee in the trust. That is, who's going to manage the trust and the trust funds after you? Well, you're going to name someone. I typically advise my clients to name 3 successor trustees, requiring the signatures of at least 2 of them. So one person doesn't have carte blanche and get on a power trip solely. So you have to name someone that's going to manage the trust after you. That's called a successor trustee. So there's a trustee, that's the one that controls it, you. There's a successor trustee, that's the person or the people who are going to control it once you go to heaven. And then there are the beneficiaries. Who's going to get the money? Okay, so you can have as many beneficiaries as you like in the living trust. You can have as much detail or specificity as you like in the living trust about how they're going to be or what's going to entitle them to the money, age, accomplishments, graduations, marriage, divorce, whatever it is. You can be very specific about the conditions that the people are going to have to meet to get the money. So again, those are the 2 ways to keep your money out of probate court. One is free, very easy to do. You have to do a little bit of work, going to all of your account holders and updating your beneficiaries. Or some of you, again, may need the living trust because, again, you have special needs loved ones, you want to leave money to minor children, you just don't want your grown children to get the money in a lump sum. Typically, those are the primary things that we want to keep out of probate court: the real estate, you, and the money. I don't really spend a whole lot of time on what they call personal property, rings, jewelry, fur coats, album collections, pictures. Here's the bottom line. That's not what your loved ones are fighting over. They're not fighting over your CD collection. They're not fighting over that 30-year-old Fox stove, with the face still on it that my grandmother had. They're not fighting over that. They're not fighting even over the picture albums. They're fighting over the money, and they're fighting over the home and the real estate. And they are fighting over who's going to be in a position to make decisions for you, because they think if they get in that position, they are in fact going to get close to the what? I know you're thinking it. I know I can't hear you, but you're right, the money. So you want to make sure those things are taken care of. But for cars, when my clients have cars that are paid for, I typically like my clients to sign the titles to the cars where it says seller, and then put it with your other important documents. And then at the appropriate time, whoever's going to be entitled to the car will just sign it where it says buyer, take it to the Secretary of State's office to record it, and then they get the car, then they'll get the car very easily. Let's see, just wanted to tell you some other just tidbits of information that you should be considering. Life insurance is something that is really underutilized in the African-American community, okay? Now, some of us are aged out of a time when life insurance is affordable for us. But I know everyone's talking about wealth transfer, and the reality is, yes, the whole America is in the midst of the greatest wealth transfer in the history of the world. That is, baby boomers are leaving more to their children and grandchildren than any other generation in the history of the world. And you know what? That includes Black folks as well. Black folks are leaving more to their children and grandchildren than any other generation, certainly in the history of the world of Black people. Keep in mind, before baby boomers, most Black people who lived in the South, a lot of Black people owned land in the South, but a lot of it was squandered, a lot of it was stolen, a lot of it is still in grandma and granddad's name, great-grandma's great-granddad's name, and it has to be probated, and it becomes so cumbersome that it's almost not even worth doing it. So, but baby boomers, and those a little bit before the baby boomer age, man, they have really done well for themselves. Their homes are paid for, they got pensions, they weren't buying $300 cell phone plans, $250 a month for cable, all these things. So they really had the opportunity to accumulate a lot of money, and they did. And so you all are leaving a significant amount of money to your children and grandchildren as well, but we want to make sure that you do it in a very efficient way, in a way that's not going to cost your family members a lot of time, stress, and money, in a way that's going to maintain control of everything for you individually and personally as well. We have a couple of questions. I'll take a couple of questions and I'll come back and just share a little bit more information with you in just a second. So we have one question here. In the event a tragedy happens where your spouse and yourself die at the same time, how would your child or next of kin get the money? Well, again, we just talked about that. I think this is Mr. Hughes. You want to make sure that you have beneficiaries on all of your accounts, or you want to have a living trust. If you don't have current beneficiaries on all of your accounts, if you do not have a living trust, then depending on the value of the account, typically over $100,000 is absolutely going to have to go through the probate process. Now, oftentimes, if it's less than $100,000 combined in a person who has passed away's accounts, you can use what's called a small estate affidavit to collect funds under $100,000. And then the issue is, well, who's going to be entitled to that money? Typically going to be spouse, children, on down the line, heirs, if you will. And so if it's less than $100,000, you can use a small estate affidavit. There is a fee for that. It's just easy to avoid paying. All of that is make sure you got current beneficiaries on all of your accounts, okay? Next question is from Ms. Francis, or Mr. Francis, please forgive me. What happens when the power of attorney becomes chronically ill, or if they have become an addict? Well, again, so the question is, presumably, if you name a power of attorney, what happens if that power of attorney becomes ill, or there's some sort of addict? Well, you can revoke a power of attorney, and the way that you revoke a power of attorney is by doing a new one. And the most recent power of attorney always trumps a previously prepared power of attorney. Or you can always just get the document and shred it. But be mindful, for someone to use a power of attorney, they actually have to have the document, okay? So I don't like my clients to give the power of attorneys to their loved ones. I like my clients to keep the documents, and when the loved ones need them, they just know where they are, they can get them in, but no one should be walking around with your estate planning information. It should all be at your, wherever you want to keep it safely. Typically, I like them at home. But whomever you named as a person to be your power of attorney, they should know that you have done it and they should know where the documents are, but they should not have documents themselves until they need them. Question, anonymous attendee. I missed most of this session because of a doctor's appointment. I hope everything is okay. Is there a replay? Jada, is there going to be a replay on this?
Yes, it'll be available on Facebook and YouTube and as well as Apple Podcasts.
Okay, thank you, Jada. We have to thank Jada. Jada's the one who put all this together for me. I just show up. Jada does all the heavy lifting, so we do want to thank Jada as well. If you have some questions about this particular seminar, you can always call Jada here at the office. Number 773-721-3333, and she can direct you to how you can get a replay. She probably can forward it to you, forward it to your friends and family members, so you can get the information again. Sometimes we do need to hear information more than once. That's why I do happen to just go over things a lot, repeat myself a lot. My wife doesn't particularly care for that much, but typically our clients appreciate it. Let's see. So here's Mr. Arnold. When should we share our personal financial information with our beneficiaries or successor trustees? Mr. Arnold, I don't think that that's a good question. It all depends on who the people are and what kind of relationship you have with them. Here's the bottom line. They don't really need to know much until they need to know it, because if you have a living trust, it's going to all be outlined in the living trust document. If you have beneficiaries on your accounts, it doesn't really matter, because whoever you name as a beneficiary is going to get the money and they're going to do with it whatever they will. So the important thing is have beneficiaries or a living trust document. And sometime, I presume, whenever you think the time is right, you may want to have a conversation with your beneficiaries and with the successor trustee. But use your own judgment about when that should be. But it does not have to be on the day that you get all your estate plan work done. It could be at your own discretion. Here's a question from Ms. Ferguson. How can you transfer a vehicle after a spouse goes to heaven? Can you just go to the Secretary of State's office with a death certificate? Well, the fact is, Ms. May, you can go to the Secretary of State's office to transfer a title to a vehicle if it's in a spouse's name. Secretary of State's office have their own small estate affidavit form that is specifically for a vehicle. So again, if you are married and husband passed away, for example, and his name is on the title of the car, yes, you have to take a death certificate. You have to fill out the small estate affidavit form properly. That's oftentimes the issue. People try to do these things on their own. They don't fill them out properly, and they just go back and forth. So you can come to our office. We can certainly help you with that, and then we can get the car transferred in your name. Seems very, as simple as you can. The small fee for us here, and a small filing fee at the Secretary of State's office to get the car transferred in your name. Again, that's why I like my clients to sign the titles to the cars. So again, once a loved one passes away, then the only thing you have to do is sign your name and take it to the Secretary of State's office and record it, and then you'll get it very easily. I want to talk about a couple, and I'll take any other questions as they come in. But since I have a few more minutes here, I want to talk about a couple of other things as well. I know some of you are concerned about what's called a Medicaid spend down. A Medicaid spend down. And Medicaid spend down is when a person goes into a nursing home. The issue becomes who's going to pay for the nursing home care. The research suggests that the longer we live, the higher probability that we will spend some time in a nursing home. Okay, so the issue is who's going to pay for it? Well, Medicare will pay for typically up to 100 days of a nursing home stay for rehabilitation. Anything subsequent to 100 days, then the issue is who's going to pay for it? Well, is Medicaid going to pay for it, or are you going to be what's called a self-pay, or are you going to be able to afford to pay for the care yourself? Well, the average nursing home stay ranges between $5,000, $7,500 a month or more. And so if you can afford to pay for it yourself, then you can, and then you're not gonna have to be involved with Medicaid. Here's how people typically pay for a nursing home without using Medicaid. One, typically if they have a pension or social security, if the amount of the pension and social security will cover the nursing home stay, well, the nursing home is going to take that off the top. But it will not jeopardize your home and your other financial accounts. Because you're a self-payer just using your pension and your social security. Others of you may have some long-term care insurance. Some of you will go to a nursing home respectfully, hopefully not, but we've seen people that say that go to nursing homes and they did have a home and they did have some money. And so Medicaid did get involved to take the home and to collect their finances, all their finances accounts, pensions, equity, and even whole life insurance policies to pay for the care. So if Medicaid gets involved, they're going to exhaust all of your assets first before Medicaid starts to pay. So if you have a home, particularly if you're single, if you have a home, Medicaid is going to take the home to pay for your care. Okay, if you have money in the bank, Medicaid is going to take that money and pay for your care, leave you no more than $2,000. And then after that, after all your funds are exhausted, or after the equity in your home is exhausted, then Medicaid will then start paying for the care. But they will exhaust your resources if you go into a nursing home and Medicaid has to get involved. Sometimes with proper planning, Medicaid does not have to get involved. And I like to try to help my clients avoid even getting involved with Medicaid. And some of you can, if you just come in and get some information and you say, oh, wow, I see how I can avoid this. So we see that over and over and over again. But if Medicaid gets involved, they're very intrusive. They want all of your records. They want all of your financial statements, and they're going to find it to see if they can collect what you have to pay for your care before Medicaid, that is, starts to pay for the care. Additionally, some of you who are married, if one of the spouses needs the benefit of Medicaid and there is a home owned between the two of them, and if they have money in the bank account, Medicaid, if you are married, will not take the home. So if you're married, Medicaid will not take the home. And if you're married and you have, if one of the spouses needs the benefit of Medicaid because they're going into a nursing home for more than 100 days. And if you are married, Medicaid will allow you to keep, I think that the number is about $180,000. So Medicaid will allow a spouse to keep $180,000 before they start executing what's called a Medicaid spin down. So if you're married, you get to keep the home, no risk of Medicaid taking the home, and they will allow you to keep up to $100,000. Anything over and above the $180,000. Anything over and above that, then Medicaid can get access to without some proper planning. That's really, really important because again, as people age, people are spending more time in nursing homes. Medicare will pay up to 100 days for physical rehab. After that, then you have to either pay for it on your own or Medicaid will pay, and then they will execute what's called the Medicaid spin down. So please be mindful of that. Again, another quick thing I just want to talk about quickly is reverse mortgages. Here's what we find with people who have reverse mortgages. Because people are living so much longer these days, when they pass away, there is no equity in the homes. So for example, if you get a reverse mortgage, the only thing that you're paying is taxes and insurance, and you're not paying any money against the money that you received, but interest is still accruing on that money. So what we're finding is when people pass away, the home may be worth $225,000, but $370,000 is owed on the home. So it's going to be impossible for your loved ones to redeem the home because they're not going to be able to get a loan on it because more is owed on it than it's worth. Now, I want you people to know that your children and your loved ones, they are very sentimental about your real estate. So you do have to do a good job to protect your real estate because, again, oftentimes families have been in these homes for 25, 30 years and longer. And then if it comes down to mom, dad, you passing away, and then the home is lost, people are devastated. They're devastated over the loss of the loved ones, you, and then they're also devastated over the loss of the real estate. So you want to make sure that you take some time, get some estate planning done so you can get these things in order. And so it's going to save your family time, stress, and money. Another this tidbit of information I want to share with you is about pre-planning for, your homegoing services. Believe it or not, pre-planning and prepaying is more popular amongst Americans than even estate planning to keep people's homes and monies out of probate court. More than half of all Americans have prepaid for their funeral services. Less than 1/3 of Americans have did estate planning. Okay, so people are more concerned about where they're going to be in the afterlife than they seem to be about who's going to get what they work for the entirety of their life. So, but again, prepayment is very important because again, the cost of funerals, cost of being buried in a cemetery, those prices are skyrocketing. So if you want to be buried, even in particular at a cemetery, whatever it's going to be, crypt, my mom's in a crypt, love it, beautiful. My wife and I, we go visit my mom. We say we want to be here too. This place is so beautiful. And then we went a couple of years ago and got a price. And then we, like everyone else, we procrastinated. Went back a couple of years later and got a price. And my God, the prices had skyrocketed just in a number of years. So if you're going to be buried in a funeral cemetery kind of setting, I think you want to check out the cost and buy it now because it's just going to be less expensive than if you pass away in another 30 years or so. So that's just another tidbit that you may want to consider. Oh, let's see. I'm going to see if you guys can see me. Let's see if this thing is working again here. Okay, here I am. Let's see if it will not start acting like one of those old TVs when you used to have the bunny rabbit antenna ears on it. Let's see, we have another question here. Let's see, this is from Phyllis. I have my property in trust, but I'm getting calls and texts from people wanting to buy my property. They don't have my name, but they do have other means to contact me. I don't know, Miss Phyllis. I'm gonna stop this because that's annoying. I don't know, Miss Phyllis, how they can do that. I don't know. Because normally if your property is in a trust, if they look at your property, your name is not on the deed. It's in the name of the trust, or if it's a land trust, it's Chicago Title Land Trust's information with a trust number. So here's what we find, Ms. Phyllis, is oftentimes, particularly with a living trust, you didn't specify what were a living or a land trust, but sometimes we see when people have living trusts prepared by a lawyer, the lawyer does not record the property into the living trust, and the property is still in the name of the person, and that's a flaw. So, Ms. Phyllis, I would contact the recorder of deeds office, or if it's Chicago, Cook County, whatever county you're in, and just confirm whose name your property is in. Is it in your name personally, or is it in the name of the trust? Got it. Okay, she has it. Ms. Phyllis, I see you have a land trust. I am not sure why someone should be having your information if your property is in a land trust. Got it. Then we have Ms. Preston asking about the price formation of a trust. Ms. Preston, I hate to talk about prices. So please call us because the price is different for everyone because different people have multiple properties and whatever it may be. So if you call us, I promise we'll give you a fee. But here's the thing, the fees are reasonable. The fees are reasonable. These are not exorbitant fees. The fees get exorbitant when you have to go through the probate process. Okay, and that's what we want to avoid. For middle-class people, you can afford to do an estate plan that when you leave our office, just like so many of our other clients say, time after time, day after day, how relieved they are to finally have this done. Because you know what, it's really painless. You just come into our office, you tell us who's going to get your home after you. You tell us who's going to be your power of attorneys after you. If someone needs to make decisions for your healthcare and business, you let us know who's going to get your money after you. That's it. And then we prepare the documents for you. You'll typically come back the following week or so to sign them. And then you have a very comprehensive, very efficient estate plan to leave your home or your real estate to whoever you want to have it, to whoever's going to be in a position to make decisions for you. They'll have the documents and the legal authority to be able to do it. And whoever's going to get your money after you, then they're going to get it. Now, I want to just share another quick bit of information too. It looks like we have I don't know how long this goes on, another 10 minutes or so. Let's call it another 10 minutes. But one of the things a phrase that I have coined is giving while living, giving while living. I oftentimes encourage my clients to give while they are living. You don't have to wait until you pass away to leave your children and grandchildren things or money. I like to, and some of you are able to do this. And again, we certainly don't want anyone to hurt themselves because again, people are living longer, you need your money, but some of you have done really well. And so some of you, we encourage you to give while you're living. Now, I do a radio show, some of you may know, every Thursday. I do it today at 3:30 on WVON 1690 AM. It's called The Legal Line. So we do that show every Thursday. Again, we'll do it today at 3:30. So if you can, please join us. It's 1690 AM, WVON. And so not long ago, I was encouraging the listeners on WVON to give while you're living. You get more calls, you get more kisses by the kids, you get more drive-bys. Now everyone wants to invite you to dinner, you get more hugs and all of this stuff. And so I was talking about that on the radio a number of months ago. And then a number of weeks later, I had a listener call in. And she told me, Attorney London, I was listening to the show and my son is buying a house. And I think I'm going to take you up on your offer. I'm going to give him $100,000 to buy his home. And she said that he doesn't know it yet. And she was asking me, well, how do I do that? How do I give him the money? Well, we talked about it a little bit. And I advised her, her question was, do I give him the money before he buys the house or after he buys the home? I said, well, you should give him the money before he buys the home so he can actually put it as part of the down payment. And that's going to significantly really reduce his monthly mortgage payment. And so, but she was so proud of her son. It was her only son. She said he was buying the home himself, didn't need her at all, didn't ask for anything. He went to school, he worked, he's buying his first home. And she said, I never really thought about giving him anything while I'm living, but she said, I can't. And so she's giving him $100,000 to put down on his home. So some of you can help your children buy homes because we know for middle-class people, whites and for Blacks, home ownership is really the foundation for moving into the middle class. And the younger your children and grandchildren can own homes and get ownership of real estate, then the more, the greater and the more solid their financial foundation is going to be. And the more and the easier it is that they can get your properties after you go to heaven without the expense and the stress and the money, that is just solidifying, again, wealth transfer. Wealth transfer is the transfer of your assets to your loved ones once you go to heaven. Now, it's only going to happen one of two ways. Again, either you're going to have some estate planning, some of the things that we talked about today, or your loved ones are going to go through the probate process. There is no other way. Okay, and so, but no, please forgive me. There is one other way, and that is once your loved ones or you go to heaven and you haven't set your estate plan up, your loved ones, they don't do anything. Do you know how many clients we have that come in and mom or dad have been passed away for 10 years and they have not probated the estate? Now they can live in the home indefinitely, but the home is still in mom and dad's name. They can't get insurance on the home. They can't get a loan on the home. They can't refinance the home. They can't pull any money out because they haven't gone through the probate process. So either you can have efficient estate planning, a trust, power of attorneys, beneficiaries, living trust perhaps, or you're going to have a will and you're going to have to go through that expensive probate process. We do not advise that. Or you're going to have nothing at all, and then it's definitely going to have to go through the probate process, and then some lawyer is going to do very, very, very well because you just didn't take the time to get it done. The number one reason why people don't get their estate planning done is not because they cannot afford it. It's just one reason. Does anyone know what that one reason is why most people don't get their estate planning done? Yes, you're right. Procrastination. Procrastination is the number one reason that people don't get their estate planning done. They always plan on doing it. We hear this time and time again where people, after their loved ones have passed away, they listen to me on the radio show and they say, Attorney London, we were going to come in. We've been meaning to come in for years and years and years, and then they just don't. The loved ones pass away, and now they have to go through that expensive probate process. Let me ask you a couple more questions here before we time out for the day. Thank you so very much for joining us this afternoon. We do this every first Thursday. Again, you can call us at 773-721-3333. If you have some questions about some of our social media platforms, you can ask for Jada. Jada, can you put the link tree up there again? And you can go to our link tree, and we have all sorts of some of these seminars and TikTok things. I can't believe Attorney Ted London is on TikTok, but I am on TikTok. Got it. Couple of questions from Miss May. If your home is in trust and someone, okay, so Miss Ferguson asking if the home is in land trust and the annual fees are delinquent, what happens? Well, Miss May, nothing happens. The property is going to stay in the trust. But when you or someone else wants to remove the property from the trust, then those fees will have to be paid up in full. So no big deal if they're late, but you'll have to pay those fees if ever you want to take the property out of the trust. Got it. Just joining. I would like to schedule an appointment to discuss how to set up my father's affairs, POAs. He put together where I call my cell. Jada, do you see this from the anonymous reader? Can you take her name and number?
Yes, sir.
Thank you so much. Ms. Robinson, we will follow up with you. I'll have Jada follow up with you, and she'll set up a time for you to come in, and perhaps you can bring Dad, and we'll go through all of it with you. Let's see. Is there any other information? I think we're about out of time. Is there any other information we can get in today? Well, I'm going to see if you guys can see me one more time. Not that I'm so much to see, but I'd like to, let's see if we can do it without all the static. So here I am. Hello, everyone. Thank you so very much for joining us this afternoon. And I'm Attorney Ted London. We do this every first Thursday. Again, we have a terrific social media presence. TikTok, YouTube, Facebook, where you can get some of this information. You can share it with your family and friends. Again, I hope you can tune in with me this afternoon on WVON today at 3:30, from 3:30 until 4. And what am I going to talk about today? I had a topic that I was going to talk about today. I think today on WVON, I'm going to talk about kind of what we mentioned earlier about so much money is going to the state because people, they're not leaving beneficiaries on their accounts, and their loved ones are not knowing where their accounts are. Kind of reminds me of my grandmother. She was so private that when she passed away, we didn't know what she had or anything. Turns out she had quite a bit more than anybody ever thought. And it turned out to be a mess. Even though I come from a real good Christian family, my aunts and uncles and mom, they fought like sinners. So even Christian folks will fight when it comes to money in the real estate when someone goes to heaven. So again, we thank you so much for joining us. You can always call our office. If you have friends and families that need information, please have them call us so they can go to the website as well, tedlondon.org. And we're right here in the South Side of Chicago. Again, for those of you who are out of state, thank you so very much for joining. We know that we have a lot of out of state listeners and viewers and clients. I think I have a Zoom next week from a client, Okinawa, Japan. And so, so not only are we going national here, we're actually going global. So we're very grateful. So to all of you, thank you so very much for joining us this afternoon. And again, we'll be at the same time,
Thank you.
same time next week. One other quick thing is, again, if you have some friends or family, you can always call us and add their names to our email list, and we'll be sure to get them invitations to our next seminar as well. Thank you all so very much. Let's see if I can wave to you without the thing acting crazy. Thank you all so very much. We're so grateful for you all. Thank you so very much for joining us.
Thank you.
Thank you.
Thank you.